breakout room with Mr. Gutierrez and go over his paperwork.
Yes, ma'am.
And Ms. McDonald, you can go to the breakout room or either you can be excluded. Mr. Gutierrez.
Just briefly, Judge, if I can go to the breakout room. Thank you.
I'm going to send you to number 4, Mr. Gutierrez.
Yes, ma'am.
All right, and we are back on the record in 2022 CR 0280. And Mercedes M., could you show your video, please? All right, could you unmute for me, please? All right, defense, you had called Ms. Mercedes Medina as a witness, is that correct?
Yes.
All right, could you raise your right hand for me, please? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand if you can state your name for the record, please.
My name is Mercedes Medina.
All right, defense.
Thank you. Good morning, Ms. Mercedes. I don't know if you recall visiting with me about a month ago when you contacted our office regarding Mark Cram's case. Does that sound about right?
I'm sorry, can you please repeat that? I have a little bit of difficulty hearing.
Sure. Do you remember calling our office about a month ago to talk about Mark's case with us?
Yes.
Okay. And that's probably the last time we did talk about his case. Is that right?
Yes.
However, when we did speak, you had mentioned that you were interested in testifying as a character witness at his sentencing. Is that correct?
That is correct.
Can you please tell this court how you know Mark Cram?
Well, I know Mark Cram because he's the father of one of my children, as well as we've been in an intimate relationship. I had met him previously in high school, just in passing. So we have quite a bit of history together.
Okay. And is it your son who is the listed victim in this particular criminal case?
Yes, Logan Favea is my son.
Okay. And when this happened, were you living with Mark Cram?
We were.
And when this event occurred, did you immediately leave with the kids to another location?
I'm so sorry. Can you please repeat?
That's okay. Did you leave Mark when this event occurred?
I did.
Okay.
Out of, just shock, I guess. I was going through a lot.
Sure. And you wanted to protect your children, correct?
Of course. That's what any mother would do. It was just a response, I guess. I don't know.
Absolutely. Now, did you receive any counseling or talk to any sort of victim coordinators about this case?
Yes, I have. I was actually, I was seen by a counselor from the family-based services by their request. And so I did speak to a counselor myself.
Okay. And did they talk to you about victims of domestic violence and stuff like that?
They did, yes.
Okay. And with all the counseling you received from them, is it still your intention to come to court and testify as a character witness for Mark's case?
It is.
Now, what is it that you would like to see happen in this case as far as his sentencing is concerned?
I've had a lot of time to think about that question. And I've had a lot of time to watch my children, how they have experienced this situation. And I hope that the court will see everything that he's doing and has done as a show of good faith, that he is capable of getting himself together. I'm hoping that he receives leniency by the judge because he has no, previous record. I'm also hoping that from the outcome today, there will be room for us as a family to grow when the time comes.
Okay. Now, you say that when the time comes, currently you have not contacted Mark, is that correct?
That is correct. I haven't spoken to him since the day of the incident, and just thinking back to that moment, all the time that I've spent between then and now, the different, advice that my family has given me, and even the words of my son, who is, the one involved. He wants to see also, when the time comes, essentially his father, who he knows him as, return back to his life. And that way his little brother also doesn't miss out on his father.
Okay. Now, if this court were to consider probation as an appropriate sentence, are you here to tell the court that he's immediately going to move back in with you and resume a family or household situation? Or are you not expecting him to move in, and maybe y'all have time to kind of discuss what your future entails?
I have every intention of doing everything necessary to make sure that he stays on the right track. And so if that means that he has to spend some more time away from us to make sure he's meeting his probationary needs, is what I expect of myself and of him as well. If that, requires additional counseling, individual, interfamily, us together as a couple, whatever it's going to take. And that's why I say when the time comes, because I know this is still in the beginning of this process for all of us. We still have a lot of time to go and more work to put in, but I know we're all as a family capable of moving forward this way, the right way.
I'll pass the witness.
State.
No questions.
All right, defense, any other witnesses?
Judge, if I can have a moment to see if my client would like to put evidence on in the form of testimony. Mark, this is your sentencing hearing, and you have an opportunity to talk to the court if you want, to explain what it is that you're seeking in the form of punishment for this offense. Do you want to testify, or are you satisfied with the character witnesses that have taken the stand on your behalf?
I'm satisfied with the testimony. I just had a few questions because the TAP evaluation stated that I would possibly get no harmful contact with Logan, as well as no harmful contact with Mercedes and Ronan.
Okay, and so first what we'll do is we'll close up the argument and then have judge make a decision, and then we can address whatever the TAP eval suggests or recommends at that time.
All right. The court will hear argument then. State.
Judge, for the agreement, state is remaining silent.
All right, defense.
Yes, Your Honor, you just heard from two character witnesses on Mr. Cram's behalf. As you know, this is a very serious charge with some very, scary facts and circumstances. There was a young child who did receive some significant discipline in the form of corporal punishment here, which by no means is something that, we're here to propose was justified. However, we do have the two most important women in his life come forward, and one of them has not had any contact with him since this offense occurred, and has testified that she acknowledges through time and conversations with her family and counselors that she believes that this was just a one-time incident, and she's interested in furthering her family.
But has she read I know she hasn't read the PSI report, but I've read the PSI report and nobody objected to it. And in the PSI report, the child is saying this is not the first time this has happened.
Oh, Judge, I apologize. You are correct. There was an instance listed in that PSI where the child had mentioned, I think there was a boot taken to the rib or something of
Yes,
that nature.
that the defendant kicked him.
Yes, ma'am. I apologize. I did forget that after reading it this morning. And so after, time and counseling, Ms. Medina is willing to work on this family unit. She is obviously a woman who can protect her children and is interested in protecting the safety of her children. She left him when it occurred, she did not know about the boot to the rib until after the fact. I think was my understanding of the PSI. And,
But I read in the PSI report that Miss Medina was upset that the police were called.
okay, my interpretation was she did not realize the police were called, so she was wondering who had called, knowing that she was not the one that had called.
All right, which seems to suggest that she wasn't going to call the police.
And I apologize, Judge, I didn't print the PSI, but I seem to recollect there was a line in there that says she intended to report it, and if we need to call her back.
No, I mean, that's not, I mean, if you want to recall her, you can, but what I read in the PSI report was that she was upset because somebody else called the police.
Okay, let me pull that PSI up.
And that's on page 7. At the top, it says contact with the victim's mother was made via telephone. Miss Medina was upset and wanted to know who called the police. Miss Medina was asked if she knew where the victim was, and she stated that her cousin Jessica had him. She was then asked if she had a relationship with her mother, and she stated that she had not spoken to her for over 2 years because she used methamphetamine. Miss Medina was asked if she had seen any injuries to her son, and she stated that she saw an injury to his ear. And the court has reviewed the stipulations, and when I viewed the stipulated evidence, there are injuries that the mother would have seen, because if the child was hit with a power strip cord, and there's injuries on his stomach, on his upper arm, on his back. And is Child Protective Services involved in this case?
They were, Your Honor. I think the investigation may be closed at this point.
Okay. All right. Defense, you may continue your argument.
I apologize, Judge.
No problem.
And so whether this court deems maybe probation is appropriate here, he doesn't necessarily have to return to the family. He has a place with his mother who would supervise, his reporting on a monthly basis and any counseling that this court deems, necessary. He is remorseful for what occurred and is asking this court to recognize that, a mistake was made. He took responsibility for it. He's entered that plea. He's not interested in wasting the court's time or resources in contesting the charges or the allegations. He did enroll in compadre to compadre counseling and is, willing to participate in any other sort of counseling that's ordered as part of probation. Alternatively, if this court deems that incarceration is appropriate here, we're asking the court to consider the minimum amount of time possible.
Right. Court will deny your application. The court is finding you guilty. The court will sentence you to 5 years in the prison, give you credit for any time served, a $1,500 fine, time and money to run concurrent. There's an affirmative finding of family violence. There's to be no contact with Logan Favela, Fabella. No harm or injurious contact with Ronan Crown, Mercedes Medina. Credit for any time served, taking consideration county court cause number 662637.
Thank you.
You're welcome. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? Mr. Crown, could you unmute? Did you review that document with your attorney? Did you electronically sign it, and did you understand it? Did you understand that document, Mr. Crown?
I'm sorry.
Did you review that document?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because there's an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. And also because it is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? Do you understand?
Yes, Your Honor.
All right, good luck to you, Mr. Cran.
Your Honor, Hector Garza, if I could.
Just one moment.
Judge, the victim wanted to do,
14G can go back, Ms. Ferguson, or did you need to speak with him?
No, Judge, I can do that.
Okay, thank you.
Judge, the victim wanted to do victim impact statement afterwards with Mr. Cram.
All right, Ms. Ferguson, can you bring Mr. Cram back? All right, Mr. Garza.
Your Honor, on Saul Martinez, I visited with Mr. Gromer. And we're talking about some new evidence that was going back and forth. And we were hoping to see if we could maybe move this to next week. There's a high probability that we're going to reach an agreement to conclude this case without the need of a trial.
All right, Ms. Ferguson. On Saul Martinez, can you put that for next week, please? Let me see what date we'll be given. So we're going to come back on April 14th.
That'd be fine.
All right, thank you. You're excused.
Thank you, Your Honor. And I can let my client know he doesn't need to come back at 1:30.
Yes.
Thank you.
All right, who are the parties on, just one moment, Mr. Cram is back. So I'll send you all to a breakout room.
Thank you.
All right, and this is, my understanding, this is victim impact. This is not supposed to be for visitation. So if she wants to just have a visitation with Mr. Cram, she needs to do that at the jail.
Yeah, she wants to do a victim impact statement since there's a protective order, so she isn't able to talk to him.
All right, but again, Ms. Medina, if this is going to be for you to have a visitation with him, then you need to do that on your own time. Do you understand?
Yes, ma'am, I understand.
All right, go forward with, you can start your impact statement.
There has been a lot of time that has passed between when everything happened and now. I have watched my son become more aware of himself and more aware of the world. And I've had to watch him go through a tremendous amount in the last 2 years. He has shared with me how much he has hurt, and he had shared with me how much he has grown and how much he has come to understand. His words to me are, I love him and I forgive him, and I hope that one day we can be a family again. And every day he tells his little brother how much of a good man he remembers him to be.
All right, Ms. Medina, you probably need to take care of the infant that's in the vehicle with you who's crying. So thank you.
Oh, snap.
Mr. Cram can go back, Norma. Thank you, Ms. Medina.
Thank you, Judge.
You're welcome.